with Lacey, our program assistant, who's running all the technology in the background, will help us out with those technical issues and getting the questions forwarded. But we're hoping to leave some time at the end for questions as well. So I'll hand it off to Zaman, and I am going to be running his PowerPoint slides. So I hope you'll bear with me as I set up the screen sharing. So just a moment here. I think I've done that right.
Thank you. Thank you so much, Amy, for the introduction and helping me with the presentation. Very good morning from Hong Kong to everybody who are joining us today in this discussion. It's in Hong Kong, it's early morning, like 9 o'clock and so. And those who are in the United States or other parts of the world, so good evening or good afternoon to all of you. In this discussion today, death penalty for sexual assault, and we are going to specifically talk about the Bangladesh perspective. First of all, I thank every one of the advocates for human rights and Anti-Death Penalty Asia Network at PAN for co-hosting today's program. Let's move on during the time of our discussion today and have some idea and share our ideas and thoughts together. So today I'm going to talk about the issue. I will try to be very brief. There are a few slides just for information and our record if we want to have some references in future. So there will be two parts in what I'm going to talk about. The first one is the context of the special penal law regarding the rape and sexual assault in Bangladesh. And the second part would be the context of overall political governance and the institutional aspects in the country. So first we will go to the law of our concern today. It's called in Bangla, Nari o Shishu Nirjatan Daman Ain. It was made in 2000, the year 2000, as an outcome of the Beijing summit about CEDAW. Government made certain commitment in those days to protect the rights of the woman, and it came into effect in 5 years' time. So this law, in its original form, it had life imprisonment for certain offenses that includes rape committed by individual offender, and the actions and offenses in the post-rape scenario, there were death penalty in section 9 in the original legislation. And the same section has been amended a little bit in October 2000, and that has brought death penalty or life imprisonment for individual crimes. So earlier, the little difference is for individual offenders, there was life imprisonment, and for multiple offenders, when gang rape or similar kind of offenses were happened, so the punishment was death penalty. And in this case, the death penalty has been extended to the individual offenders instead of life imprisonment. I hope it doesn't sound too complicated for our understanding. And then I just referred to the sections, and it's also hyperlinked with the law. So for example, if you click on number 1, where section 9 is shown, click on that, the whole text of the law. Unfortunately, it's in Bangla only. The official website of Bangladesh government will appear, and you can check the legislation by yourself. if you have interpretation or the language skill. So now the question is, what triggered this amendment in the country? The latest amendment, it happened October 13th of 2020, just less than 2 months ago. So the next slide, I tried to give a little bit of background. This is a case that all you see in this. In very simple words, the case is about a woman of 37 years of age. Some local youths were trying to, insist the lady to something that no woman would be able to accept. And she is a mother of 2 children. Her daughter is married already, and the son is quite grown up. And so in that context, the husband has a second wife. He lives mostly with the second wife, but at the same time, visits her occasionally. So the people who were insisting the woman, who ultimately became the perpetrator in this case, they wanted her husband not to be with her, and they take the advantage. And that is the conflict between the woman and these people who had certain political influence in the locality. And at one stage, the consistent refusal of the woman to agree with these people resulted to a shocking incident that the perpetrators stripped her naked, and then they tortured her. And that incident of torture was video recorded in their cell phone, understandably. And for about a month, the family went into hiding, and they were also trying to find the woman and get their intentions unleashed. But and when they failed, nearly in a month's time, those video was uploaded to social media as a form of retaliation against the woman to stigmatize her in the society. And then it went viral, and this from Facebook, hundreds of people were protesting against that, criticizing the government, and later it became a news item for the national media, and then it moved to the international media. So in this, a few links to the story of different media, I tried to provide just to be authentic and also for reference for the future. So in that context, many people in different parts of the country in Bangladesh took to the streets, demanding justice for this victim. And I must say that this is not an isolated incident in the case of Bangladesh. There were many in recent months and also in recent years. All were humiliating incidents, very sensational, and that also outraged people. But at the end of the day, everyone got frustrated. So in this case, the government tried to, pacify or cool down the situation, because there were some people who are known to be friends to the government. They also raised voice in this case. They could not take this much. So in that context, the government thought we need to do something. And that something is promulgating an ordinance. And the ordinance wanted the amendment to Section 9 of the Nari or Shishu Nirjatan Daman Ain, Women and Child Repression Prevention Act of 2000. The act was previously amended in 2003 on few provisions. but not exactly regarding the death penalty. It's the aging of to define child of 16 years of age. And then we got this, this new form of the legislation. On 13th of October, the president of Bangladesh promulgated this ordinance as the parliament of its kind in Bangladesh. It was not in session. And later on November 17th, the parliament ratified it. So that's how it stands now. Now the next slide, I tried to give an idea to the audience the impact when any government introduces a new legislation. There is certain expectation, and the population who are supposed to be part of that or abide by or face the law. So there would be also certain impact on that. And in this case, the expected impact was deterrence. I mean, to stop such kind of crime, sexual violence against women. And but now what I found in this shortest span of time, a national vernacular daily, it published a report analyzing its own report between 13th of October and 13th of November. During this 1 month period, they tried to see that what is the immediate impact of this law. And their story suggests that there is an increase of sexual crimes, particularly rape, by 58% in comparison to the immediate previous 30 days. So, I mean, this is too early to judge or conclude, but the amendment has taken place, it's less than 2 months now, but this also indicates certain things, that the change of the legislation and the way the information has been communicated to the society, particularly the offenders who are committing the sexual violences against the women in the country, there has been no deterrent impact on those population, at least those potential offenders. So this is the law part that I thought that we should discuss. Now, if we ask the question that why harsh legislation did not help Bangladesh to create a fear about the crime and to reduce, triggering reduction of the recurrence of the crime. So then there is the second part of my presentation that briefly talks about this. I'm trying to be, am I running out of my time, Amy?
No, you're fine. Go ahead.
Okay, so I will try to be very quick. So in this part, what we need to see that the aspects of overall political governance, why certain people do not feel afraid. And in the case, there is one information is very important, that the perpetrators of sexual violences in Bangladesh are mostly, their political identity is they're mostly associated with the ruling party of Bangladesh of current time. So at present, the ruling party is Bangladesh Awami League. So it has many political units, youth wing, students wing, and very workers wing. So most of the perpetrators that have been identified by media reports, their political identity suggests that they belong to the ruling party, or somehow they are associated with the ruling party, and they use that influence when they commit the crime. So now in this case, there are a couple of instances that throughout the tenure of the government, what we see that presidential clemency was used to free convicted criminals like murderers. And I tried to use a link to the reports that is available in the media, and human rights organizations have reported to that. So each of these underline that you see, if you click on that, so something will come out as reference. Then there has been a pattern that if an alleged offender is associated with the ruling party, then the law enforcement agencies exclude those perpetrators or alleged perpetrators from the criminal charge, either at the stage of complaint mechanism, when the registration of case is taken care of, or at the later stage during the criminal investigation of the case, the police very nicely, they drop the charges, or they make the charge so weak in the investigation report that the prosecutorial process is just becomes a matter of time to for them to walk free. The perpetrators can walk free. So it becomes a matter of time for them. Then the other aspect is the government very consistently used the judiciary and the Ministry of Law, Justice and Parliamentary Affairs and the Ministry of Home Affairs to, grant impunity or kind of release, arrange release for some of the, many of the perpetrators that are also associated with the government somehow in some form. And then there is in Bangladesh is well known for its culture of impunity to the perpetrators of law enforcement agencies who commit sexual crimes, who also commit gross human rights violations, including enforced disappearances, extrajudicial executions in very high number in the pretext of war on drug and many other excuses, and so on. And then there is also a pattern of rewarding the perpetrators in many ways. For example, the commanders of the law enforcement forces made ambassadors to different countries, ambassadors to Spain, ambassadors to Morocco, ambassadors to Saudi Arabia, the former police chief who should be held responsible, as their command responsibility for the extreme form of human rights abuses that have been taking place in the country. But the scenario is opposite. Many of the perpetrators, individual perpetrators, were given gallantry awards like the Presidential Medal and also Police Medal and Independence Day Award. So many kinds of very high profile awards and other kinds of facilities. At the same time, very much lucrative postings, promotions. And on the other hand, there is a pattern of retaliation against whoever disagrees with the government. So in this case, I have used the reference, the former Chief Justice of Bangladesh, who happened to be a close ally of the government during his time in office, except very few cases. And one of the major events that the Chief Justice disagreed was the 16th Amendment of the Constitution, where the government wanted to make the judges accountable and impeachable in the parliament. And the judiciary, the appealed Supreme Court, disagreed with that and said this is unconstitutional and it's a threat to judicial independence. And after that, he was forced to leave the country. So if you see the link here, there is a report about the Chief Justice later wrote a book, and he basically described in his own account how things happened in his case and that triggered his forced departure from Bangladesh. And to my knowledge, he is living in Canada and seeking political asylum at the moment. Then we go another part of the part two, the institutional aspect. So I tried to be very brief here. The Bangladesh institutions being, it had its colonial legacy. It was never perfect, and nowhere it is perfect, but it was, not a very well functioning institution. Mostly under Pakistan and under since independence of Bangladesh, only the letterhead changed, that I say, that there is no very fundamental institutional reform that has never happened. So that, wreckage of colonial institutions, it has been further damaged under the incumbent government in various ways. So I just cited few examples of that. For example, the Election Commission facilitated ballot stuffing overnight. Many people call it midnight election. So that means the Election Commission and law enforcement agencies facilitated ballot stuffing on the previous night of the election day. So like they finished everything before the official election hour began. And Transparency International of Bangladesh, that I linked here, they found 47 constituencies out of 50 experienced that kind of ballot stuffing in 2018 December election. I'm not going to talk about even the previous ones that were also equally worse. Then the Anti-Corruption Commission, it has established a pattern, and nobody believes this institution as a credible one, because it often certifies the high profile people having allegation of corruption as Mr. Clean or Miss Clean. So that's what the people have experienced. They do proceed some cases if the people are opposition leaders or government leaders, but not with high profile, smaller, low-ranking bureaucrats mostly, and not high-profile political people or high-profile bureaucratic law enforcement officials. So if you look at the National Human Rights Commission, it has also a similar pattern of behavior. And overall, the most important institution, set of institutions is the criminal justice institutions. So when we talk about criminal justice institution, we know that we talk about the policing system, we talk about the complaint mechanism, the crime investigation, the forensic medicine examination system, and the adjudication system in the court. And this entire process, their recruitment, their training, everything, the handling of everything, their budgeting, everything suggests you that these institutions are designed to dysfunction in Bangladesh. And since the colonial wreckage, it has never been improved, and gradually it's just declining to its worst. So the people have that set of kind of institutions for holding the perpetrators accountable. And then it has a legislature. I don't need to go further about that, because when you see the ballot stuffing overnight, so everyone understands what kind of legislature is there. So the legislative accountability or judicial accountability is quite impossible in the context of Bangladesh today. So now the point is, when you have a culture of impunity on political, on political motivation, then there is very less to expect. So with that, you have to always think that the way forward, how we move on. So I just did not make the list long, and I thought it is not practical to do so. So the number one point, in my understanding, is that it should begin with restoration of at least electoral democracy with credibility, so that there is a fear of accountability from the top political and high profile people. And if that comes in, then it will transmit the message to the grassroots level politically empowered people that there will be certain consequences. Because in a country like Bangladesh, the opposition only faces criminal charges. The ruling elites never do so. So if there is a fear of coming to the opposition again, then there will be the fear even of committing crime or the consequences. The second thing is transformation of the criminal justice institutions. The way I said it, it's not that easy task. It's a very huge work, and it would take decades. I don't know when that is going to begin in today's Bangladesh, as we see. And then it also requires redesigning the system of governance, and that will require a lot of other legislative changes and various other things, and the culture and the change of the thought process of this, the ruling elites, including the bureaucracy, politician, and also I would say the civil society of this country. So that's where I want to end, and I thank you in advance for asking questions and for everyone's patience. Thank you very much, Amy, for your great help.
Thanks so much, Zaman. It was really interesting and very helpful to have the context of what the situation is in Bangladesh, and sort of what the impetus was for expanding the application of the death penalty to include rape as well, and how that arose, and what the larger issues are in the country with respect to the rule of law. What I'm going to do now is, first I wanted to talk about Bangladesh is not unique in this regard. There are global trends regarding the death penalty for rape. According to Amnesty International's most recent report, there are 3 countries that actually carried out executions for rape in 2019. That includes Egypt, Iran, and Saudi Arabia. And the United Arab Emirates has also issued death sentences for rape. And there have been new movements toward expanding applicability of the death penalty for rape. Thailand adopted a new law in 2019 authorizing the death penalty for rape leading to death. Nigeria's Kaduna state signed into law in September of this year a new law that allows the death penalty for rape. India, of course, also instituted amendments to its criminal penal code in 2018. Pakistan as well has currently allows the death penalty for gang rape, and there have been initiatives to expand that. And I heard from another World Coalition Against the Death Penalty member, ACAT Liberia. They informed me that this year, the president of Liberia, George Weah, has called for the death penalty for rape. Also, the Chief of Staff of the Armed Forces of Liberia has made that call. And according to ACAT Liberia, the Congress in Liberia is preparing a death penalty bill for rape, and the bill is gaining public attention. Particularly troublesome in Liberia because Liberia has ratified the second optional protocol to the International Covenant on Civil and Political Rights, committing itself to abolition of the death penalty. And instead, it sounds like the leadership is moving in the wrong direction, expanding the scope. So while Bangladesh is a particularly alarming situation, it's important to address this issue not only in the context of Bangladesh, but globally. And with that, I think it's important to touch on the international human rights standards that apply to this context. Now, first, I want to talk about rape. And rape, of course, is a human rights violation. And we know that gender-based violence, the incidence of gender-based violence has increased during the global pandemic. And so we don't mean to downplay the serious human rights violation that rape is. The International Covenant on Civil and Political Rights, Article 7, 11 says that no one shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment. Bangladesh ratified the International Covenant in 2000, so it's a state party. And experts at the United Nations have said it's well established that rape and other forms of sexual violence can amount to torture and ill treatment. In addition to the severe physical trauma, the mental pain and suffering inflicted on victims are often exacerbated by the social stigma they face. And that was a statement on March 8th, 2018 by the Special Rapporteur on Torture and several other UN experts addressing this issue. Also relevant to the discussion is the issue of marital rape. And marital rape is also a violation of the physical and psychological security of the person, also is a human rights violation. When we talk about rape, we often think about private parties as the offenders. And of course, as Zaman alluded to, in some cases, it's of course government officials who commit rape and sexual assault. But even when it's private actors who commit these acts, the government has an obligation, which we often refer to as the due diligence obligation, to prevent, punish, and investigate or have redress for these human rights violations committed by private parties. So the Human Rights Committee, which is tasked with interpreting the International Covenant on Civil and Political Rights, issued a general comment in 2004, general comment number 31, and it says that the positive obligations on state parties to ensure the covenant rights will only be fully discharged if individuals are protected by the state, not just against rights by the state's agents, but also against acts committed by private persons. And there may be circumstances in which a failure to ensure covenant rights would give rise to violations by state parties because the state parties permit or fail to take appropriate measures or to exercise due diligence to address those human rights violations, to prevent them, punish them, and investigate them. So the state parties have to take positive measures to ensure that private parties don't inflict torture, including torture in the form of rape. So that's a really important principle when we talk about the human rights violations associated with rape. The Committee Against Torture, and Bangladesh ratified the Convention Against Torture in 1998, in its general comment number 2, also talks about this due diligence obligation of the government to address private actors who commit acts of torture. So the state's indifference or inaction can be a form of encouragement or permitting or authorizing this torture, and the state party has this obligation to prevent and protect victims. There's also a general recommendation from the CEDAW committee, general recommendation number 35 on gender-based violence against women, that's informative here. So that's a set of human rights violations and obligations on the state parties, but now we're going to shift and talk about the death penalty. The relevant international human rights standards here is Article 6 of the International Covenant on Civil and Political Rights. It says that every human being has the inherent right to life. This right shall be protected by law, and no one shall be arbitrarily deprived of his life. And Article 6, paragraph 2 says that in countries that have not abolished the death penalty may be imposed only for the most serious crimes. And so that language is quite relevant and important when we talk about rape. The Human Rights Committee in 2018 issued its general comment number 36 on Article 6, the right to life. And it said that this term, the most serious crimes, must be read restrictively and pertains only to crimes of extreme gravity involving intentional killing. It expressly said sexual offenses, although serious in nature, can never serve as the basis within the framework of Article 6 for the imposition of the death penalty. So the Human Rights Committee stated clearly, plainly, in no uncertain terms, that if there's not an intentional killing, the death penalty is off the table. Including sexual offenses are off the table for imposition of the death penalty. Another relevant part of that general comment is paragraph 44, where the committee said that the death penalty must not be imposed in a discriminatory manner. And based on Zaman's comments, you see that it is, the prospect of prosecution and application of the death penalty is being applied in a discriminatory manner based on political opinion. And that is a matter of concern. Also, paragraph 34 of the general comment says that state parties may not transform into a capital offense any offense that, upon ratification of the covenant or any time thereafter, did not entail the death penalty. So that comment also says countries cannot expand their use of the death penalty, which is what Bangladesh is attempting to do, and what these other countries are considering doing as well, in violation of the International Covenant on Civil and Political Rights. I just wanted to talk very briefly about the history of the death penalty for rape. And countries may think, well, this is a way of standing strong against gender-based violence against women by having these really strict penalties. But in fact, these strict penalties are part of an ancient patriarchal view of women that treats women as property. Under the Hammurabi Code, rape was defined as the theft of virginity and embezzlement of a father's daughter's fair price on the market. It was treated as a property crime. And if the victim was married, then she was found guilty of adultery and thrown in a river along with the assailant. So the victim was also treated as property and treated, in fact, as a criminal. And the rationale behind all of this is the conception that a woman who is raped, her purity has been undermined and she is therefore damaged goods. And the law in many contexts and cultures views this rape as a crime against the man, either the victim's father or her husband, not against the woman who is raped. And that's why in many countries, and I understand that Bangladesh allows this as well, a rapist can escape prosecution if he marries the victim. That purportedly undoes the damaged value to the father's property. That's also why in many contexts, a man cannot be convicted of raping his wife. And in Minnesota, that was there were some obstacles to prosecuting men for raping their wives until very recently. So in many contexts, historically and culturally, the history of the death penalty for rape was actually mired in negative patriarchal views of women as property. Also, where the penalties are more severe, both by law and by custom, there have been heightened obstacles to achieving accountability. So there have been rules requiring the victim to have corroborated testimony, including under Islamic traditions where the death penalty was applicable, but only if there was a confession or if there were 5 Muslim men of good standing who were witnesses to the rape. But also under other traditions, there were rules allowing introduction of evidence about the victim's prior sexual conduct, as if that would be evidence of whether or not she was raped. And other examples, the American Bar Association in 1938 adopted a resolution that supported the requirement of mental examinations for any prosecuting witness in a rape case, saying that the severity of the penalty calls for special procedural precautions to protect an innocent accused from condemnation by unreliable testimony. So a lot of these obstacles, of course, would deter a person from reporting rape and pursuing charges in the first place, but also meant that there were lower conviction rates. And looking at some common colonial history in Britain, they abolished the death penalty for rape in 1841. And prior to that point, for the century prior to that point, the conviction rates for rape were as low as 5%. And from 1940s onward, the conviction rate went to 50%. So it's actually much easier to obtain convictions when the death penalty was off the table. So just to wrap up here, these heightened evidentiary standards also suggest that we mistrust women, and that women that the law is supposed to protect the virtue of women, but women are also potentially wrongful accusers, and we need to have a lot of barriers to prevent that from happening. And what we really need in taking a human rights approach to this issue is an approach that's centered on the survivor of the rape, that's centered on the victim. And ratcheting up penalties is simply changing a piece of paper. And it actually undermines the approach of focusing on the survivor of the sexual assault. It harms the survivors, it reduces accountability, and actually promotes impunity for rape. So I'm going to hand off with that to my colleague, Karen Long, who is a staff attorney with the Women's Human Rights Program at the Advocates for Human Rights. Before joining the Advocates, Karen worked as a prosecutor in Minnesota for many years, and including prosecuting cases involving violence against women. She was a former assistant Ramsey County attorney and also a former staff attorney at the Minnesota Coalition Against Sexual Assault. So she has a lot of experience with investigating and prosecuting sexual and domestic violence cases. And I think it'll be really interesting to hear her perspective on the situation of the death penalty for sexual assault and rape, but also what are the good practices for addressing the issue. So thanks so much for joining us, Karen. We look forward to hearing from you.
Thank you, Amy. And I will share my screen here. And I just want to be sure I'm sharing one that says the Advocates for Human Rights.
Yep.
Still getting more comfortable with how to screen share. So yeah, I'll just continue on with Amy's point that while it can sound very tough on crime or tough on rape to implement the death penalty for any crime, whether it's murder or rape or others, the reality is that there are so many problems before you get to the penalty phase with sexual violence prosecution that actually, if we really want to do better on holding sexual violence offenders accountable, there are many things that need to be done before we start worrying about what the penalty is. And in fact, as we'll talk about in a minute, and Amy mentioned, the death penalty probably actually is a barrier in and of itself to holding offenders accountable. So let's see if I can get my screen to advance here. So, well, obviously, before there's any penalty phase in a criminal prosecution, there has to be a report to law enforcement. So the law enforcement investigation or any prosecution obviously begins with somebody going to law enforcement. And most of the time, of course, that's the victim of a sexual violence offense, herself or himself, reporting to the police. And if there's no police report, then there's no prosecution. And if there's no prosecution, there's no finding of guilt and penalty. And so the real difficulty and trouble in holding sex offenders accountable is in getting victims to go to the police and make a report, and then getting a sufficient investigation that it can result in a conviction. And so if states are serious about improving the response to sexual violence, the penalty is not the place to start. The place to start is in looking at the actual system where that currently results, as Amy said, in very few convictions. And worldwide, there are probably less than 5%, maybe less than 1% convictions for sexual violence. The United Nations has described the reporting rate, so talking about the rate of women or men who go to law enforcement and report a sexual violence offense. They've described that rate as dramatically underreported or rarely reported to law enforcement. In the US, when researchers have performed victimization surveys asking people about the experiences that they've had, what they have found is that less than 25% of women in the United States report sexual violence to the police. And so getting people to the police department is the biggest hurdle. And then, of course, coming up with sufficient evidence to move forward is another hurdle. But I always say, if you want to hold offenders accountable, the criminal justice system needs to be a soft place for victims to land. It's a very tough crime to report. It's a tough crime to experience, of course, and it is a very difficult experience to go through reporting and prosecution. And so the criminal justice system has to learn how to be a soft place for victims to land, because there are so many barriers. And so let's talk about a few of the barriers to holding offenders accountable. And as Zaman said, you know, where criminal justice institutions are not functioning up to human rights standards, then we are not going to see accountability for sexual violence. They're not going to be holding offenders accountable. So number one barrier, ineffective police response. And this can range all over the place from either not taking a report, and there are many nations, and I think Bangladesh is one of them, where it's fairly common that the police simply will not even accept or take a police report from the sexual violence victim. Or certainly if they do, they take it with a note or level of suspicion. As Amy indicated, this is an offense that brings with it these cultural myths that women cry rape, that they lie frequently about rape, although there's no evidence to support that false reports of rape are any more common than anywhere else. But the police often respond with a lot of suspicion and cynicism, and instead fail to do their due diligence as required under human rights standards. As Amy mentioned, there are often heightened evidence requirements. There must be a witness, or the victim must have an injury in order for the police to take it seriously. A large barrier that we see in many places is a lack of protection for victims. You can imagine experiencing something so violent and frightening, and then learning that there's no protection order. And in Bangladesh, protection orders are few and far between that would say that the offender may have no contact with the victim or may not harass the victim. If those orders are not, they don't exist, or if they're not enforced, then the victim can feel very vulnerable to ongoing threats and pressure from family members or other members of the community. And so a lack of protection can be a huge barrier. And then, of course, an ineffective prosecution and court response. What I understand about Bangladesh, but certainly is present throughout the world, is that for sexual violence offenses, often there are huge delays. It can take years, even in systems that are nominally working pretty well. It can take years for sexual violence cases to go through the court system. And I understand in Bangladesh, there are delays of sometimes 4, 5, 6 years from the time of the offense before the criminal process is finally resolved. And of course, that results in victims losing their resolve to stay with the process, or feeling pressured, or continuing to experience all the fear and concern about moving forward with the prosecution. And of all the offenses out there, sexual violence is the one that carries with it these cultural myths and misunderstandings. So whether that applies to how the police respond, whether it applies to how the fact finder at trial might evaluate the case, and how a judge might evaluate the case. This whole notion, as Amy was saying, of women sort of being responsible for their own victimization or being held accountable at times, that can look different ways. It can look like either they have to marry the offender in order to save their reputation, or they're thrown in the river or whatever. But I mean, in the state of Minnesota, you know, the woman who's had a little too much to drink or stayed out a little too late with somebody also can be blamed in part. So blaming the victim for the offense is rampant when it comes to sexual violence cases. And absolutely stands in the way of both effective investigations and also a finding of guilt ultimately. So again, if we have all these barriers and we never get to the penalty phase, then the death penalty doesn't mean anything. Life imprisonment doesn't mean anything if you can't get there in the first place. And then I'll just add to all these other barriers, once there are intersecting forms of vulnerability. So if a person comes from the LGBTQ community, if they are a person who lives with either physical or mental health problems, disabilities, if they belong to a less dominant culture or class in the society, all of these things can exponentially create barriers. And we see extremely low reporting rates for those people who experience other intersecting vulnerabilities. And so, you know, what we really know is that what deters offenses like sex offenses is not what the penalty is ultimately, as long as the penalty has some weight to it. I mean, we wouldn't want to treat this like stealing a candy bar, but you know, as long as the penalty has a decent weight to it, what really provides accountability and deterrence is the likelihood of apprehension and the likelihood of being charged and going through the criminal justice process. So the likelihood of the death penalty is not what will deter people. It is the likelihood of getting caught. And so what we want is for people to get caught and held accountable. And adding the death penalty at the far end of that process, in addition to the barriers we've just talked about, actually just adds more barriers. And so let's talk about that. We know that generally, most people who are victimized by sexual violence know the offender. Amy mentioned intimate partner or marital rape. That is a huge number or percentage of women who experience sexual violence or do so at the hands of their intimate partner as part of an ongoing domestic violence pattern, usually. And then another huge percentage of women know the offender because they are in the same community. They are students at the same school, they work together, they're neighbors. It might be another family member. So most people know the offender who sexually assaults them. And so what that brings with it is all the pressure that comes from the family, the community, the fellow students, the fellow coworkers who know the offender. There is usually often a cultural preference to protect the offender and to undervalue the harm that's caused to the victim in sexual violence. And so the victim will usually have a barrier to reporting to law enforcement, is worrying about the pressure that's going to happen, and also sometimes concern about the assailant and what will happen to the assailant. Oftentimes, especially if they know each other pretty well, the victim will worry that she's going to ruin his life. And of course, if you add the death penalty, that adds just another layer of concern and reasons why people would avoid accessing the criminal justice system after sexual violence. In my many years working with victims of sexual violence, I like to train law enforcement officers to ask the victim as they're doing their investigation, you know, knowing that many people do not report sexual violence to law enforcement, but knowing that, why do you report it? And the number one reason, almost to a person, is so he won't do this to someone else. What we don't hear usually is because I want him to spend the rest of his life in prison, because I want him to get justice for what he did to me. It's actually so that he won't do it again. And so victims normally are not clamoring for outrageous penalties. They just want him to stop. And then the death penalty, I think, carries with it this notion that the victim might as well be dead. It's such a horrific thing to have happen, and that she might as well be dead, and we should hold him accountable for that. But my experience is that while of course sexual violence changes the victim's life, it rarely ruins their life. There are times when people can actually find silver linings in some ways. They find strength that they didn't know they have. They find a community sometimes that they didn't know they had. And no one would ever minimize what's happened to them, but often I think the point is we don't need to treat the sexual violence as though it automatically ruins someone's life to the point that death penalty is an appropriate response to that. And then I think it's worth pointing out that, as Amy said, normally what we anticipate is that the death penalty is for homicide, that it is for an intentional killing. And a savvy perpetrator may decide that it's no worse a penalty for sexual violence than if he just goes ahead and leaves no witnesses and takes the life of the only witness to the crime, because of course it is usually the only one other person there. So I think that's worth thinking about. I'll run through these super quickly. This could be an entire 5-day training, and I'm not going to do that. But how do we increase accountability then? Well, we create a victim-centered response, and we coordinate that effort so that we provide ongoing support and protection throughout the entire process to the victim of the offense. We do have competent forensic medical examinations available. The police response is by well-trained expert police officers who specialize in sexual violence. The criminal justice system then should prioritize sexual violence cases so that they don't languish forever and lose victims along the way. And so coordinating a healthy and robust criminal justice response is actually how you increase accountability for sexual violence rather than worrying so much about the death penalty. And then I have to add this in because deterrent is one thing and accountability is one thing after the violence has happened, but the state also has the obligation to provide public awareness and education. And actually that's how you stop sexual violence, is changing the cultural norms that lead to it. So with that, I will stop sharing my screen and turn it back to Amy.
Thanks so much, Karen. I think that was really helpful to give us some ideas about why these efforts to expand the application of the death penalty to include rape are really the wrong solution to what is a really horrible problem. That it's in a sense, it's easy to change the law, to just like add an extra line, changing the penalty for something. And the things you've described that actually address the root causes and provide support for victims and promote accountability, those are hard. Like those are systemic responses that require people to be really invested in doing things the right way. It's not a cheap one-off. It's something that's really, that requires a really thoughtful response. And it's in a lot of countries, it's like the death penalty is sort of this easy thing. Oh yes, we instituted the death penalty. We're now tough on sexual violence. Whereas the harder, heavy lifting is what really needs to be done. And this quick fix type of approach is in fact counterproductive, as you suggested. Now I know we're just a little bit over time. I don't see any questions in the chat, but I want to encourage people to pop some questions in the chat. And while we do that, maybe I'll turn back to Zaman to give any response to what you heard from Karen. Does this give you hope or any direction or any further ammunition for the situation in Bangladesh?
I mean, of course, first of all, thank you very much to Karen for this very comprehensive presentation. I liked it very much. And the way you have, described in such a short time, it applies and it reflects many places. And of course, Bangladesh is in that. The major difference is that, for example, in the United States, you have an efficient criminal justice system. There are facilities like forensic medicine expert, and even it is from a non-partisan, impartial, independent professional perspective, it is possible to address this problem because of the infrastructure and the commitment. The criminal justice system, it already has within. So, and Bangladesh is many light years away from that reality. It is unfortunately. So that is the area that I mean we need to go in the context of Bangladesh. It's I fully agree that I mean changing law is one thing. It might be just using your parliamentary majority, but then and certain backdoor works, but then changing the society and I mean administering justice to the victims. That is it's unbelievable challenge. And in Bangladesh, it's the bigger problem is today. Like day by day, we grow up and we try to articulate the better way, how to make our tomorrow better than today. So that should be when we look at a nation, for example, nation state in today's concept. So if Bangladesh is a nation state and it's a functional state, it has the ultimate intent or commitment to uphold the rule of law, to administer justice to everyone, whoever faces a crime, faces a violence, including sexual violence. Then there has to be that kind of matured commitment and planning that should lead the institutions toward improvement to the extent that there are many things. For example, if the one case that I just referred in my presentation, the incident happened for 1 month. This family did not go to anywhere, not to the police, not to anybody, because they were pretty sure that they're helpless, absolutely helpless. And they left their home and hiding in a place there so that nobody can find them, for not only for protecting themselves from the social stigma, but also the further damages, further attacks on the entire family, because they refused to some people, they said no to some people who are known to be powerful. And then there is a complete alienation of the law enforcement system into that incident for a month. So, and what has happened, it's not too much, I mean, just 2 complaints have been registered, but there are many instances in that country that, for example, there was a guy, again, happened to be a student leader, secretary of a university unit of the ruling party, the same political party back in the 1990s, late 1990s. He celebrated 100 rapes in the university campus. Most of the victims were students of that university, and few were, pedestrians and the neighborhood who passes through the university campus, workers, ready-made garments workers, and like that. And what is more shocking is that the government harbored the victim from the country's jurisdiction to Europe. It's government did it. So when you don't need to do anything if you do this. Whatever you do, it simply doesn't matter. Mm. Committing one crime is enough to get punishment, but committing more than 100 crimes of rape, and he just cut cake to celebrate with candles that I have achieved it. So for that kind of shame was given protection by the state, by the highest political authorities. So in that kind of, when we sometimes our imagination fails to understand how this is possible and how it happens, but that is the reality that we live in. So in that context, there are many things is required at this moment. So, and that's why, I mean, in my way forward, I did not go for, I mean, not too many things, because I know what the universal standards and norms are, the UN human rights mechanism and what it talks about. But at the same time, I have been seeing it while I personally sit in the UN Human Rights Council or the treaty body sessions, and then I see how Bangladesh government is exploiting all those platforms, how they're disregarding those mechanisms, how they're lying to them blatantly. So seeing all those things, I just went to try to be at the core of the problem that it has. So, much of your presentation, it applies to the case of Bangladesh, but at the same time, Bangladesh deliberately put himself far behind than, improving and coming to the track of making its rule of law system functional, or the criminal justice system capable of administering justice. So for that, there should be, right now, if we want something to happen, one of the ways, for example, creating some accountability, which I did not say in my presentation. If I give a reference, for you may remember that in late October, no, it's in August, I guess. The US bipartisan Senate Foreign Relations Committee, they wrote a letter basically urging sanction for the commanders of Rapid Action Battalion who have committed human rights crimes, including enforced disappearances and extrajudicial executions. So because the domestic criminal justice system, the political system, the legislature, everything failed itself. It's made to fail by the authorities themselves. So then they want this impunity to be like this. Otherwise, they will not survive, because who is going to rig vote for a regime if they don't guarantee impunity for the state actors and the non-state actors of their own political parties? So if you cannot stop that in a system, then you cannot expect any accountability. So right now, for example, with this Magnitsky legislations that in the United States, the GLOMAG, and also in the UK, European Union, they have adopted their individual legislations. I don't believe it as a form of accountability. It's a kind of political tool, so to say. But one of the things is that all the corrupt money, the undeserving assets that these law enforcement officials and the top bureaucrats, they acquire by abusing their power in Bangladesh, that comes to these developed jurisdictions like United States, Canada, UK, and many other places. So if you can use this sanctioned regime against some of those perpetrators, and then for example, in the disappearance, there are military officers who are involved in that. While they serve in the DGFI, Directorate General Forces Intelligence, and also the Rapid Action Battalion, the police also commit enforced disappearances and extrajudicial executions to a large extent. So if those officials are prevented from UN peacekeeping missions, for example, then that would create impact. And that may, in today's context, lead toward the acknowledgement that, okay, we need to do this, because acknowledgement should come first, that we are far way behind and what we are doing is extremely wrong, and this itself is crime. So if that acknowledgement is triggered through any kind of exercise that is available beyond the jurisdiction of Bangladesh. And then if that effectively takes place within a reasonable time span, then at least the acknowledgement will also lead to certain thoughts that, okay, how to minimize this. They will first think how to minimize this. So there are many ways, like you suppress it so that it is not exposed. You retaliate against human rights defenders, like many of our colleagues, when they speak out, so they fail retaliation. The Anti-Corruption Commission and the other governmental institutions, instead of going after the perpetrators, they go after the civil society groups who raise their voice. So if that is made possible, that the independent human rights activists are protected, and then some of the perpetrators, the key commanding people, are held, are facing any kind of consequences through these sanction regimes, then something will, that will lead to something. We are still not certain that it will exactly bring us a changed, transformed criminal justice system as a whole. I don't believe that that is also possible in a very shortest possible time, but somewhere we need to begin. And I think, that's where we can concentrate to at this moment with our capacities. I thank you very much.
Thanks so much, Zaman. And yes, I think it's really important the way you highlighted that there are these real structural problems. And as is so often the case, when there's a disregard for the rule of law, when there's impunity, it's the most vulnerable people in society who suffer the most. And we need to take steps, as we often say in the human rights world. It's not a sprint, it's a marathon. And there's a long way to go in Bangladesh and in other countries, but looking at these underlying structural issues, looking at these root causes for impunity are really important. So we've gone over time. I apologize, and I thank those of you who hung in with us. I think it was a really interesting discussion. I learned a lot. I want to thank Zaman and Karen for your contributions to the discussion, and thank all of you for tuning in. And also, for those of you who are interested, the Advocates for Human Rights has its online auction going on for another 15 minutes. It closes at 8:30 in celebration of Human Rights Day. So check that out if you are an online competitive shopper. So thank you all for joining us, and stay tuned to the Advocates for Human Rights on social media for upcoming events. And again, a thank you to ADPEN as well for helping to spread the word about the event. And we're really glad that ADPAN is there on the ground in Asia, keeping an eye, monitoring the situation in Bangladesh and elsewhere as well. They do really important work. So thank you all for joining us this evening or this morning or wherever you are, whatever the time of day is, as the case may be. Thanks so much.
Thank you very much for having me.